Start. Para. These 4 appeals are directed against judgment and order dated 11/2/2008, passed separately in each suit. The suits are filed against 4 tenants by the same landlords for possession of the tenanted premises on common ground that those are required reasonably and bona fidely for immediate purpose for demolition and erection of new premises in its place. Thus, the landlords in all 4 cases are common, though the tenants and their tenanted premises are different, but the grounds of eviction are common in all suits. Similarly, on going through their written statements filed separately in each suit, it appears that the grounds of objection to resist the relief are also identical and common. The evidence laid by the parties is also appears to be common, except the evidence of tenant in each case is separate and distinct from each other. Further, the judgment and order in 4 cases is passed on one and same date with similar reasoning. Considering all these similarities of the 4 suits, the fact that grounds of eviction as well as defense of tenants in all the cases are common and identical, therefore I proposed to decide these 4 appeals by common judgment. Parties to the proceedings are referred with their original status before trial court for sake of convenience. Particularly, the plaintiff number 1, being builder developer, is referred in his same capacity. Para. The facts giving rise to the present 4 appeals can be summarized in short as under. Before adverting to the contentions of parties raised in their respective pleadings, it is useful to refer few undisputed facts revealed from record of the case and pleadings of the parties. It is not in dispute that the city survey number 425/B admeasures 223.2 square meter situated at Shaniwarpet, Pune, is the subject matter of the suit. This premises is divided in 2 parts. One part consists of 2-storied building and another consists of 3-storied building. The said premises was originally owned by Sri Purushottam. The plaintiff number 1 is builder and developer by profession. Initially, Mr. Vinayak has decided to develop the entire suit property and has got executed 3 different development agreements from the respective owners. The development agreement executed with heirs of Sri Purushottam is dated 7/7/2004. That of plaintiff number 2 is dated 16/7/2004 and that of heirs of Janardhan is dated 11/5/2006. It is also not in dispute that all the defendants are tenants of the family. The premises occupied by tenant is admeasures 292.94 square feet. The premises occupied by tenant is admeasures 180 square feet each. Similarly, the premises occupied by tenant is admeasure 65 square feet. Her premises is of shop premises and premises of other 3 tenant is residential premises. It reveals from the record that while plaintiff number 1 was intending to develop the suit property, he decided to give premises on ownership basis to the extent of premises in their possession. At the same time, it was agreed between them that in case if the tenant wants to purchase additional area in the new building than that of occupied by them in old building, in that case they are required to pay additional charges regarding the additional premises. A joint meeting was held between all sitting tenants and plaintiff number 1 on 19/7/2004 and on 28/11/2004. The proposal put forth by the tenants in the meeting dated 19/7/2004 was not agreeable to the builder developer. Therefore, he made endorsement to that effect on said proposal. Consequently, same could not be materialized. However, the second proposal put forth in the meeting dated 28/11/2004 was accepted by the building developer, and in response thereto, the tenants have given their consent in notarized form on 5/1/2005, enabling the builder developer to sought necessary sanction for demolition and reconstruction of the building on the suit property. Stop.